Good afternoon, everyone. Welcome to another edition of Medicaid Monday. Frank Hemming, my partner, and I will be walking you through Medicaid financial eligibility. And we'll just start a little bit with the people on the screen. This is our firm, Pierro, Connor and Strauss, with offices here in Albany, New York City, Garden City, Lake Placid, and other locations, Hudson, New York, around New York State. We do a lot of work in the elder law Medicaid area, and it's something that we pride ourselves on. So today we're going to be bringing you information on financial eligibility, how to prepare, how to plan, how to become eligible for Medicaid, what's in the wind, what kinds of changes are we anticipating, because we always have things moving in Medicaid, especially with budgets. I will not pontificate because we only have 30 minutes on what's happening right now at the federal level with the House of Representatives bill and what's happening at the state level with the New York State budget. The New York State budget is not terrible, but the federal budget could be. If the House cuts go through at $880 billion coming out of Medicaid, all of this becomes very dynamic and the change will be rapid, as we've seen with changes in the government most recently. Medicaid home care, we'll talk about what those rules are and what changes might be coming. Legal strategies, differences between nursing home and home care, which are still significant, and why all of this matters. And with that, I'm going to turn it over to Frank Hemming, our in-house Medicaid expert. Frank?
So updated numbers, so just in case you're new to us or haven't seen these before, but we did get new numbers in February this year. So income is now up to $1,820 per if you're a single individual. So that's somebody at home trying to get home care services. Again, income for one person is $1,820 per month. If you're a couple, it's up to $2,453. If you are the well spouse of a spouse that needs Medicaid, that means that your income limit also went up to $3,948. And the bottom number hasn't changed in forever. It literally has never changed. So if you are that institutionalized person in the nursing home, your income allowance is $50 per month.
New York is what's called an income spend out state. This is very much a state by state issue. Other states are income capped states, and you need different types of planning depending upon what state you're in. With a spend down state, we're going to talk about how to spend that income down and how to use something called a pooled income trust, which becomes very relevant when you start talking about Medicaid home care and getting down to eligibility limits for income, which you see here on the screen. We also have eligibility limits for assets. Frank?
So resources or assets, either one, term is interchangeable. So again, good news because they're up just a little bit. So if you're one person, your individual asset limit is now $32,396. If you're a couple, it's $43,781. And then if you're the community spouse, again, where your spouse is on Medicaid and you are not, then the lower tail of your asset amount is that $74,820. It's been that number for quite some time. The upper tail went up to $157,920, so up just about $3,700 from last year.
And again, state by state, this varies. Most of the contiguous states around New York have a $2,000 individual asset cap. The other spousal cap is different. New York has an artificial cap that was put on by Governor Pataki a number of years ago. That $74,820 number has been with us now for, I don't know, a dozen years or so, plus a kicker of 50% of the assets if they're over a certain level. Very complicated, but suffice it to say that New York is much more generous for individuals, and for married couples, kind of the same as most of the other states. And if you have clients or constituents that have applied for Medicaid or asked the question, can I become eligible for Medicaid? Do I have too much in income? Do I have too much in assets? What's the answer, Frank?
The answer is you could be right now, but there typically are planning techniques that we can use as attorneys to get you eligible, whether it's using trusts or gifting or spousal refusal. We're going to talk about all those today.
And we have segmented, because we're only 30 minutes on each of our Medicaid Mondays, we have segmented presentations on home care and nursing home care, both financial and all the other eligibility criteria, the qualifications. This is the financial home care presentation. And for this, home care, Frank, has very, very different rules.
Yes, I mean, generally speaking, and this is good, is home care rules are much more generous than nursing home rules. We will touch base a little bit later with a slide or two that talks about, some of the big differences. But again, just to kind of reiterate for the 1,000th time, there's still no look back for home care, right? We think there could be a look back coming maybe later this year, could be much more distant in the future. I don't think we've seen any real guidance or updates on this in quite some time. And with everything else going on in the Medicaid world, I'm not sure that they're really even focused on this right now. But the opportunity remains that if you have somebody in your life who needs home care, technically speaking, you still can get qualified and apply and get approved for Medicaid with no look back for now.
And we've been waiting and waiting and waiting for Department of Health to give us guidance on when the 30-month look back will be implemented for home care. Again, this was passed about 4 years ago, I think now, during COVID, but delayed because of the federal health emergency, and delayed, I think, because New York State has also a waiver that they have to get to implement this. And there are practical considerations that we have gone through in prior webinars in the implementation of a home care look back. Very different scenario than a nursing home look back, because it's pretty clear that if you're in a nursing home, you're otherwise eligible for Medicaid, but that determination is much more difficult at home. So for home care, we have different components of Medicaid financial eligibility.
Right. So you have to be financially qualified, which talks about your assets and your income. That's kind of why we wanted to recap the numbers at the start of the presentation. One, they're good to know. Second, because they go right in line with the topic for today. So in order to be eligible for home care, if you're a single person, again, you have to have no more than $32,396 of assets when you go to apply. So the way Medicaid works is they take a snapshot as of the first of the month as to what your assets are. If you're below $32,396 as of the first, then you're good from this perspective. If you're over, then there are very limited things you can do to then still qualify in that month. Most of the time, you're going to have to wait until the following month, where then again, as of the first, you get down below the $32,396 number. We also have to look at your income. Again, 1820 is the limit. We have plenty of people that tell us all the time, well, I'll never get Medicaid because I make too much income. That's a much different kind of calculus than the asset test. Because if you make more than 1820 of income, then typically the result would be you'd be given a monthly spend down amount from your local county Department of Social Services. And there are other things that we can do with your spend down, and we're going to talk about that in just a little bit.
So Frank, if a client walks in the door today on April 14th of 2025 and says to you, Mom has $200,000 of assets and $4,000 a month of income, can she be Medicaid eligible? And if she can be, when?
She certainly can be. Question would be when. Ideally, she would be eligible by May 1st. It all just depends on what that $200,000 of assets consist of. If it's something that can move very quickly, whether it's cash or real estate, things like that, then certainly May 1 would be achievable. If it requires movement of funds like with a brokerage company or a life insurance product or something like that, then June 1st might be the more realistic expectation just because of just paperwork getting handled. But May 1 would be the target date for sure.
And again, there are exempt assets. If someone is living at home, the home is exempt. IRAs, probably the biggest issue.
Yeah.
We might want to just touch base on IRA planning.
Sure. No problem.
Whether traditional IRAs and Roth IRAs qualify.
Yeah. So there's no actual guidance on Roths. There still hasn't been anything released to my knowledge. Doesn't mean that we won't see something at some point. But essentially, retirement accounts, so you have your 401k, IRA, 403, 457, any of those tax-deferred retirement accounts. They are treated as exempt in New York as long as they are in payment status. So I'm sure if you're not thinking of it now, you will later if you think about it. So a Roth doesn't require any withdrawals from it. That's one of the beauties of a Roth. So with a traditional IRA, once you've reached 73, you're required to take distributions from it. So once that happens, that automatically puts those accounts into exempt status for Medicaid purposes. If you're before 73, so if you're 70, 71, 72, you can always start distributions early. That could exempt the account as well. Roths, because they're not required to take distributions, what we have done in the past is we have essentially treated them as if they are traditional. We've done the calculation and basically set up a required distribution using the same math from a Roth. And so far, the counties have all accepted that, and thus your Roth would be exempt just like your traditional. So again, just like as Lou was saying, there are state differences that mean a lot in this area of law. Your IRA being protected is one of the benefits of seeking Medicaid in New York. Many states do not protect IRAs, although Florida does. I just learned Vermont does, or at least that's what I was told, but there are not many that do.
Now,
So if you're talking to somebody not in New York, make sure that they get local counsel and advice about this specifically.
and the major change that has occurred over the last couple of years, other than Nassau and Suffolk County, which have implemented this rule, is the requirement that someone maximize the income from an IRA. And my question is, but no maximum. So when we look at this, there was an administrative directive that came out, I believe, last summer. Maybe the summer before, it might be losing track of time.
That's right.
But it said that counties must maximize income. And what does that mean, Frank, to maximize income? Maximize income, I can take it all.
I was gonna say, that's why I think generally we've always had an issue with just the phrasing of that, because technically the whole retirement account could be withdrawn. So a maximization withdrawal from an IRA would be to liquidate the entire account. And so far, that doesn't seem to be what the state intended when they put the phrase together, maximize the payment.
It comes from periodic payments, which is in the POMS, the Social Security POMS, which is where Medicaid derives its asset rules from the SSI rules. And all it says is periodic payment status. New York has amplified that to require maximization of income. I'm not sure where that authority came from. I've tracked it. I've actually done a fair hearing on it. I'd love to get a client that wants to go to an Article 78, but that's another matter. Let's go to medically eligible.
Yeah, so on top of the financial piece, you also have to be medically eligible. So for now, again, there were changes that were discussed previously, and so far as we know, these have been tabled of requiring more than two ADL assistants. So for now, to be medically eligible, you need assistance with at least 2 activities of daily living. They include everyday things like bathing, dressing, grooming, eating, transferring, ambulating, and using the bathroom. So there are other what are called incidental activities of daily living. So things like medication management, shopping, things like that. There are other things that obviously you as a human being would need to do to survive. So it's not saying that those don't come into the calculus either when our determinations get made, but more than anything, you need assistance with at least 2 of these things. If you have more, that's not a good thing. It's bad for your predicament, but it's good for qualification purposes. But again, there had been talk of increasing this to 3 ADLs, and for now, we don't believe that that's going forward as far as we know.
And if you want to go back to the good old days, when departments of social services did the assessments, did the healthcare side in addition to the financial side, you had a county health nurse typically going out and doing these assessments. That changed dramatically, and most recently, it is now the NIA, the New York Independent Assessor, that goes out and does the preliminary assessment, and then you have a physician that does the secondary assessment, and then you have a managed long-term care company that typically does a third assessment. We have a separate Medicaid Monday show that will track all of that and what the nuances are and what needs to be done throughout that process. And I don't know when we're going to bring this up, but I'll bring it up. And that is, a lot of these assessments are now being done through the Consumer Directed Personal Assistance Program, which, as almost all of you know that have listened here, we had Valerie Bogart on last month talking about the changes in PPL and the implementation of the single fiscal intermediary. We're tracking that very closely. I'm sure many of you are as well. There are no less than 17 lawsuits around New York State. There is an injunction currently on the amplification or the rollout of the single fiscal intermediary, and a directive that other intermediaries can still handle cases. We're going to be tracking this. And if you are not signed up for the Elder Law Forum, which is May 15th, we will be having representatives, Valerie Bogart, from consumer side of things, And we've also invited PPL to the table. So we're hopefully going to hear from PPL. We have a call today at 2:30 to talk about their appearance and to get their take on the implementation and what they're seeing and what they're doing to implement this. And we have a delay, of course, from April 1 now to the end of April. We'll see how that all plays out. So what about income when they tell you, and I can't tell you how many clients walk in my door and say, well, I went and asked if I could be eligible for Medicaid, and they said, no, I make too much income.
Sure. Well, the good solution is here on the screen. I guess the other solutions are you can either spend it down, right? So you can literally hand it to your local county, or you can spend it down on other medical things like co-pays, medical bills, prescriptions, things like that, and actually show the county that you've done it. That would also cure the problem if you have too much income. But most people don't want to do that, or they have too much money to do that, or they need their money for other things. So instead, we counsel our clients to create and fund something called a pooled trust. It's a trust that we specifically use just for income. There are trusts we use for assets, but this is an income trust. And essentially, you take the excess monthly income above 1820 and you put the money into this pooled trust account. It's administered by a nonprofit charity. And then the charity then can use that money to pay your bills and expenses and things that you then would send to them, and they would pay them on your behalf. So whether that's your cable bill, your phone bill, your real estate taxes, additional home care services, technology services, pretty much anything that benefits the Medicaid person, they will pay. And that's how most people can stay at home. Because honestly, not many people, if anyone, could survive on $18.20 a month if that's all that you had to support both yourself and your household. So it's kind of the vital cog of making the income or the financial piece of Medicaid home care actually work and function.
There are a number of qualified pooled trusts around New York State. They have to be not-for-profits. And again, what's left in the pooled trust at the end of the day goes to the not-for-profit. So when you have high income spend downs going into a pooled trust, it takes a little creativity to spend the money, Frank.
Yeah, it's very interesting always to try to counsel people on kind of that shift in thought. Because I think many people, as they get older, they constantly are thinking, well, I have to save, save, save. I don't want to spend, spend, spend. I need this money for me. And unfortunately, if you get to the part where Medicaid's then needed, when then we have to flip the script. And now if we're using a pooled trust, we actually want that thought process to pivot to spend, 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 because we want you to use your monthly income as much as possible. Just because, again, if you were to pass away, if there's any money in that pooled trust account, it stays with the nonprofit charity that administers the pooled trust. So it would certainly go to a wonderful cause if something did happen to that person and they passed with money in the account. But at the end of the day, they want you to use your money for yourself just as much as we want you to. So with creative thinking and creative planning, there are usually some other creative ways to spend the money, whether it's paying, additional caregivers, it could be getting some technology in the house. There's room and board agreements sometimes if they're living somewhere else. Obviously, if you live in an apartment, it's great for rent payments. So the idea is just to kind of spend that money as much as possible, or have an exit strategy for it within a few months if you need to save up some money to pay like your real estate taxes or things like that, because sometimes we have clients that need to kind of do that instead.
And if the client has a home and they're responsible for the maintenance and upkeep on the home, then you can make home improvements as well.
Sure.
And maintenance and new roofs and sidewalks and those kinds of things. So caregiver agreements for children is an option. So the pool trust is the way to get down to the 1820 monthly income, and then working with your pool trust administrator, your trustee, to get that money spent on good things that are necessary for the individual. And it has to be the individual, not others.
Yes.
So that's one limitation.
Yeah. Now we have seen some flexibility come in with this. The pool trust we've been working with most frequently, they've gone, I think, a little bit away from it has to be exclusively for the benefit of the person to be, they have to be like the primary person, right? Or it has to be certainly for their benefit. It doesn't mean it can't benefit other people within the household. So some rules have, I would think, lessened to a degree, but ultimately, yeah, it has to still benefit the Medicaid person, right? Just to give an example, if somebody has a life insurance policy, like if the Medicaid applicant or the Medicaid recipient has a life insurance policy, they will not use pooled trust funds to pay for the premium for that life insurance policy, because that no way benefits the Medicaid recipient. That benefits the beneficiaries that inherit the money from the insurance product once they pass away. So that's a small example, but that would be an example of something I know the pool trust would not do. Other big one, positive, can guarantee it right now. Pool trust will never dispense cash to the Medicaid applicant or Medicaid recipient. It's not just like a bank account where you just have to go to somebody else to give you your money. They have to maintain control of it and make sure that it's spent appropriately.
And we do have a separate Medicaid Monday on the administration of the pool trust.
We do. We have at least 2 in the library with Sarah Grimes from NYSARC, who's a good friend of ours. So if you have questions about this specifically, certainly go back on the library, check out the pool trust.
And there will be a panel at the Elder Law Forum on Medicaid home care, and part of that will be
Pool trust.
the pool trust.
Yeah.
So what about assets, Frank? How do we get people Medicaid eligible? And we're talking primarily now about home care with regard to the assets.
Yeah, so typically the tool in our toolbox is we're going to use an irrevocable trust or a Medicaid asset protection trust. We have many different names for things. We love acronyms, but essentially we're usually going to recommend that you create a trust and then you put stuff in this trust, and the trust then protects things for Medicaid. It creates essentially immediate eligibility for home care, and it creates 5-year protection for things after 5 years for a nursing home context. And if we don't have the ability to use a trust, or sometimes if we're thinking there might be other considerations going on, sometimes we use something called spousal refusal instead.
So for most clients, they have IRAs, 401ks, and that for virtually all our clients walking in the door today, they have some element of that. Those don't go in the trust, don't have to, because if you're taking those periodic payments, the IRA 401k is an exempt asset. But we use the trust, and we can do this again right away, very quickly, get it funded and create Medicaid eligibility for home care quickly by the first of the next month, and get this trust up, running, funded. The IRAs stay put. We can keep a certain amount of cash, $32,000 if it's a single individual. Married couple, you have to look at what the circumstances are, but they'll get the extra community spouse resource allowance. And then we look at how does that trust operate and how does it work so that our clients have a comfort level using a trust that is irrevocable.
So we put your assets in, right? This is your cash, it's your life insurance, it's your stocks, it's your properties, it's whatever it is. So all your assets above that $32,000 figure, plus your IRAs and other exempt property goes into this trust. We typically would allow income to come back out of it. So if there's a stock portfolio in here, if you make interest and dividends on the stocks, you can still get that even though you're on Medicaid. Sometimes people rely on those funds to be able to upkeep their home and pay their monthly expenses. So if we've done this in that context, it's additional monthly income, and then it gets funneled into your pool trust, or then it could be used for your benefit, just like we just talked about. Sometimes if you don't need your income, we don't give it to you. But for most people, we typically do. The trust is then managed by a trustee. This is typically a child or somebody else in your life that you trust, but you can change your trustee whenever you want, for any reason that you want. So while you give up control, you're giving up some control, but not all of it, because if they don't do what you want, you fire them. And then we name beneficiaries to say who inherits the property. And there are ways that, as long as you do it carefully, we can get assets out of this trust and ultimately used for someone's benefit. The biggest thing here is money or assets within the trust cannot be given directly back to the Medicaid applicant. That's the biggest no-no there is. So that should never, ever, ever happen with a trust like this.
So for a lot of clients, they have heard one thing, and that is, I'll have to run to my kids every time I want money. Well, we leave enough money, especially if you're pre-planning, so that you have a comfort level. You keep enough money in your checking and savings accounts so that you have access to cash as you need it. Remember, you always keep your 401k, IRA outside the trust. You have access to those funds as well. The funds in the trust would be going in, and they would look like your home, bank accounts, stocks, bonds, annuities, life insurance, businesses, other real estate. You keep the income from those assets. You keep the right to live in the home, to use the property for the rest of your lifetime. The principal is what is locked in. And as Frank said, to unlock the principal, you can make distributions from the trust to anyone else other than the two spouses. And that money could then be used by those beneficiaries for anything that they choose. And we typically counsel, if it's multiple children, we counsel the kids to open up a joint bank account and to gift themselves $10,000 and move it into the joint bank account. And then they can buy things for mom and dad. They can pay for trips. They can put things on the house. They can buy dad a new car. And so that money could be used by the children for any of those purposes. The question then becomes, Frank, do I trust my children?
I hope so, right?
I do.
I say,
I do.
If you don't, then you shouldn't be putting them on as trustee, right? And then you may not want to name them as equal beneficiaries, but that's all things that are customizable within this kind of plan. And that's why we like to spend a lot of time with our families when we're counseling them about what the plan could look like, to try to make sure that we're kind of hitting all these little details. A lot of people want to just have all their kids involved. They want to treat them equally. And if that's your circumstance, that typically makes our job easier, but that doesn't mean that it has to be that way if you're looking to do something.
Yeah, and I trust my kids, but do I trust their spouses?
Good point.
The in-laws, that son-in-law that wants to get his hands on my money to start his new business. So we keep the powers. The big stick is not the power to change trustees. You can always do that, but you can also change beneficiaries. So if a child or a trustee is also a beneficiary, you can remove them as trustee. You can also remove them as beneficiary, so you control who the beneficiaries are. And New York has this wonderful statute called EPTL 7-1.9, which says, with the consent of those beneficiaries that you're naming, you can actually revoke an irrevocable trust. So those are all the safety features and security features that we build into the trust that clients can have, so that they get a comfort level having their assets held in a trust that they're not the trustee of, but they are the beneficiary of, with all of these different provisions that give them that security. Right?
So if we do all that, you get all these advantages that we just went through. You get still access to all of your income, because you still get your income in retirement. You still get your money into your own accounts. If you're on Medicaid, you can use a full trust, and you can get income from your trust account if you want it. We preserve your principal to be there for your lifetime, with a backdoor out through your beneficiaries if you need it. It's preserved for your beneficiaries when you pass away. And then you also get tax benefits from doing all this too. So one of the big things that people get worried about are capital gains. And if people inherit through this trust, it wipes out capital gains. And it typically doesn't put anyone in a worse tax position because of the way that we draft the trust.
Yeah, the trust is very favorable from a tax perspective and a Medicaid perspective. So far, they have not tinkered with it. 1993 is when Over 93 passed, and that's when these trust rules came into effect. We've been drafting trusts based upon these laws, federal laws, and New York State has to comply with those federal laws for that time period. And now we'll see if it gets changed, but the one comfort that we have for our clients is they do get grandfathered in. So we just want to touch quickly on another phenomenon in New York State. If one spouse needs Medicaid and the other one is healthy and living at home, we have the ability, Frank, in New York to do something called spousal refusal.
We do.
So what is it?
Essentially, it's a statement signed by the well spouse, essentially saying, I need my income, I need my assets for me. And because this is a creature of federal law, the counties, when we apply, have to respect this document. And essentially what the document does is it allows the county to process the Medicaid application just based upon the income and the assets of the applying spouse, without looking at the income or the assets of the refusing spouse. Because there are plenty of times like where when we apply, the refusing spouse has more than their income allowance, which is that 3948 number, or their asset number, which is that 74820 number. So if you have more income, more assets of the spouse, you have to refuse, because without it, your spouse wouldn't get Medicaid. But there are issues and risks that come with spousal refusal. So unfortunately, while it's such a good tool in our toolbox, the risk comes that if you do refusal, it opens the door for the local county to come and sue the refusing spouse. This could be for income, it could be for assets, it could be both. This is a very county by county situation. Not every county sues, or not every county is as litigious as others. But every spousal refusal case that we do, we counsel clients that this could become a reality. As scary as it sounds, it usually is in the best interest of the family to still pursue this route, even though it sounds really scary.
So when we look at the eligibility for home care versus nursing home care, most of the clients that we have want to start with home care and want to try to work out that home care plan, which we work very hard at. And the hard part now is trying to find caregivers, which we can talk about and will in another session. But the look back for nursing home care is 60 months. So if you have one spouse that needs to go to a nursing home, you can still use spousal refusal at that point and get Medicaid to turn on the Medicaid spigot. We then recommend for the healthy spouse, because once the one spouse is on Medicaid, the other spouse has no limitation on what they can transfer with regard to that Medicaid spouse's eligibility. So we do a Medicaid trust for the healthy spouse to get those assets out of the probate estate into a protected trust and to at least have defenses should the recovery action come. In most cases, we have settled those. We haven't had one in a very long time, I will say that. In most cases, when we have settled them. And when you have a trust, it's very hard for the county to reach those assets. So it does provide another line of defense. And even if they get every penny, Frank, you're still saving about a third of the Medicaid or the nursing home bill.
Yeah, that's one of the kind of the weird benefits of doing all this is if you do get sued by the local county, the county can only recoup back what the county paid on your spouse's behalf. And because the Medicaid rates are as low as they are, repaying the county still comes at a financial savings because those are less amounts than what you would have paid privately if you hadn't done this at all.
So financial eligibility has not changed dramatically since 1993. 2006, they extended the look back from 36 months to 60 months. We've had other minor issues along the way, bumps in the road. We had a statute that brought in a state recovery against all assets, including trusts, but we were able to lobby against that and actually get that statute repealed. And right now, Medicaid eligibility from a financial perspective is doable. The hard question now is, once you get financially eligible, what happens? How do you find caregivers? What happens with the consumer-directed personal assistance program? What happens with the nursing home transition diversion waiver program? How do you get care? How do you pay for care? How do you go through the NIA process and the MLTC to make sure you get the amount of hours that you are entitled to? All issues that we will cover at the Elder Law Forum and in our other Medicaid Mondays.